The violence-hit area of Jahangirpuri, northwest Delhi on Wednesday saw officials of the North Delhi Municipal Corporation or the NDMC demolishing shops, temporary structures and the external gate of a mosque as well, which the authorities claim was illegal. Now, while North MCD Mayor Raja Iqbal Singh called the demolition drive normal routine work, senior advocate Dushyant Dave called the demolition drive completely unconstitutional and illegal while mentioning the matter before the Supreme Court, which did order a status quo in the case. But what is the procedure for removal of illegal encroachments, and can raising down illegal encroachments be linked to riot accused? I'll tell you in this episode of KYC or Know Your Constitution. Now, to be clear, there is no parliamentary law which allows the demolition of property of those accused of rioting or damaging public or private property. The presumption of innocence, which has been considered to be a part of Article 21 of the Constitution, in fact would bar any such action against those who are just accused. But the government can demolish someone's private property if there is any illegal construction on government land, or if the construction actually encroaches on another person's land or property, or if the structure fails to comply with regulations. This power is given to municipal corporations across the country through different laws in different states. For example, a demolition drive similar to Delhi was undertaken last week in Khargone in Madhya Pradesh following the communal violence on Ram Navami. Now in Madhya Pradesh, Rule 12 of the Madhya Pradesh Bhumi Vikas Rules 1984, a notice needs to be sent to any person who is using a building in violation of the rules, and it requires them to be given 10 days to either leave or fix the illegalities. However, while officials in the district administration said that those whose houses and businesses were razed were given prior notices, reports claim that this was not the case in MP. Similarly, when we speak of Delhi, Section 343 of the Delhi Municipal Corporation Act 1957 talks about such a notice. It says that in cases where any building which has been constructed illegally, without sanction, or in violation of building bylaws, the commissioner can order the owner or occupant to demolish it within 5 to 15 days. Failing this, the commissioner then may himself order for demolition of the structure. The provision in fact says, and I quote, "No order of demolition shall be made unless the person has been given by means of a notice served in such manner as the commissioner may think fit, a reasonable opportunity of showing cause why such order shall not be made." Basically, the person needs to be given a reasonable opportunity to present their case. It also says that anybody aggrieved by the commissioner's order can file an appeal against the demolition order in the appellate tribunal within the period specified in the demolition order. When such an appeal is filed, the tribunal can also stay the enforcement of the demolition order. So there's an entire procedure that's been put in place. And the Delhi High Court has called this a mandatory requirement under Section 343. And this is what the residents of Jahangirpuri are claiming wasn't done in their case. They were not given any such notices. Now, why is such a notice usually considered mandatory? It's because one of the very basic principles of natural justice, which actually forms the basis of judicial procedure for civil or criminal cases, is the right to be heard. Whether you're making a decision about the guilt of someone accused of an offense like theft or about which of the two squabbling neighbors owns a patch of land, it is absolutely essential to hear both sides before you make up your mind. The right to be heard, to allow the other party to present its case, has therefore been ruled to be a part of Article 21 of the Constitution, which says that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This procedure established by law should be followed strictly and should also be fair. So the courts have often explained how getting a notice, issuing a notice, it's extremely important, because unless a person knows what they are being accused of, they cannot defend themselves. So this is a part of this fair procedure that the Constitution envisages. And the courts have time and again emphasized on the need for a notice when it comes to demolition specifically. And the courts have time and again emphasized on the need for such a notice when it comes to demolition specifically. In fact, in 2017, a district court in Delhi had referred to the need for notice under section 343. In this case, a person's house in Delhi's posh scenic farms was demolished, and the court was so aghast with how the procedure wasn't followed and no notice was issued in this case that it directed the authorities to either build a quality home for the owner of the house or pay him 1.5 crore within a month. I have also written a more detailed article on the procedure to be adopted for removal of illegal encroachments. I will include the link to this article to the description of the video. That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram and Facebook.